Morning. Please be seated. This is the time set for oral argument in City of Phoenix et al. Against ORBITZ et al. Our cause number 1CATX160016. Counsels, I'm sure you're aware we have read the briefs, conferenced the case, and are generally up to speed on the record, so you can bear that in mind as you begin your presentations. Each side will have 20 minutes for oral argument, and the appellant is free to reserve as much time as you wish, but you're responsible for watching your own clock. And if that, we can begin. Thanks.
Good morning. Allison Ho on behalf of the online travel companies, and I'd like to reserve 5 minutes for rebuttal. May it please the court. It is axiomatic that business privilege taxes cannot be imposed on persons who do not exercise the business privilege. The cities here have enacted a tax scheme that imposes obligations on persons for the privilege of engaging in certain business activities in Arizona. At issue here are two of those business privilege taxes. Section 444 imposes taxes on the business privilege of operating hotels. Section 447 imposes an additional tax on owners of hotels.
And is that even a privilege tax, 447?
It is certainly listed among the privilege taxes. I agree with you that it is more of an additional tax that applies under 447. It's an additional tax imposed on hotels or owners of hotels.
It's drafted like an income tax. No matter where it appears, it literally says a tax on the income, which is not generally the way privilege taxes are written. So,
I think it is certainly included in that part of the code that is labeled privilege taxes. I think the privilege, if you read on, is furnishing rooms. That's sort of what I would identify as the business privilege of furnishing rooms or lodging. But it's clear that in all events it is imposed on owners, on hotels defined as owners.
Ms. Ho,
yes, Your Honor.
Judge Whitten, in his minute entry, found that the OTCs are brokers. If the OTCs aren't brokers, how would you define what you do?
Certainly, Your Honor, and I think significantly, Judge Whitten also found that we were not operators of hotels or owners of hotels. We describe ourselves as intermediaries, as facilitators. We act as a facilitator on behalf of the travelers on whose behalf we facilitate making reservations with hotels.
Counsel, as I understand it, and please correct me if I'm wrong, your clients actually buy the room from the hotel and then sell it to your customer, the traveler, correct?
No, Your Honor, and thank you for the opportunity to clarify that point. At no point do the online travel companies buy or purchase rooms from the hotels. And in fact, we cannot even make a reservation without the hotel's approval of it. And our contracts with the hotels make very clear at no point do we have rooms, do we have ownership or control or possession of rooms for purposes of selling or renting to travelers. The service that we provide to travelers, and I think the trial court actually keyed in on this correctly in finding that we are not operators of hotels or owners of them, is we facilitate reservations. The traveler wants to make a reservation. We transmit that request to the hotel. The hotel is free to turn that request down.
But the traveler does the traveler pay you, or does the traveler pay the hotel?
In terms of once the hotel agrees to accept the reservation, we are certainly the merchant of record, and the traveler pays us.
I guess that's where I'm getting hung up. I mean, I take your point that you're not buying rooms and reselling them before the customer has made the reservation. But if you're the merchant of record, you're the company actually selling that hotel room for the period of the reservation.
Respectfully, no, Your Honor, because we never, at no point, do we take ownership, control, or possession such that we can sell the room. And I think importantly here, even if, assuming we did sell, that wouldn't be a basis for imposing privilege tax liability here under either operator, owner, which the trial court agreed we don't do, or the broker, which is a very specific definition.
And I mean, please don't mistake my question. I'm not asking these questions with an eye to thinking you're a hotel. That's not where I'm going, but the idea of brokering rooms does have more appeal than the idea that your clients are operating a hotel.
Well, and I think it's significant. I think it's significant in that regard, Your Honor, that the trial court here, in holding erroneously in our view that we're brokers, really applied its own sort of common law definition of broker, and didn't apply the very specific definition of broker that is in the code.
And I want to get to that, but first let's talk about let's break down the money. It seems to me, as I understand it at least, that you collect the entire fee for the reservation. A portion of that is remitted to the hotel. A portion of it is designated as taxes. The hotel pays a tax on the revenue it receives, and then the OTCs pay nothing in taxes. So you're collecting taxes but not ever paying them. Is that right?
No, not exactly, Your Honor. What we are doing is we are the merchant of record, right? So the traveler pays us for the room rate, and also for our services and fees associated with the services that we perform.
Isn't a portion of what you charge the customer designated as tax?
It is designated as a tax collection fee. So yes, the customer pays us. It's designated a tax collection fee, and then the hotel and all that amount. Now, what we charge for our services is never transmitted to the hotels.
I understand, but there are three buckets here, right? There's the amount paid to the hotel, there's the amount that you get as your service fee, and then there's this mysterious tax figure which isn't even computed based on the location of the hotel, as I understand it. It's just some estimate of taxes, none of which is ever remitted to a taxing authority. Is that right?
Your Honor, no. The hotels at all times bear the responsibility for remitting the taxes, and they do. Then they invoice.
But it's only on the amount. The tax is based on the amount that on the rate that you've negotiated.
It's based on the amount that the hotel charges for the traveler actually to occupy the room. That's correct.
Based on what tax rate?
Based on whatever the tax rate is in the jurisdiction issue, and the hotels pay that.
It actually varies. Then it's not just an estimate based on some amalgamated tax rate. the tax actually varies whether you're in Phoenix or Chandler or Trenton, New Jersey. You've got tax tables for all these jurisdictions and compute it separately?
It's my understanding, and that's why it's referred to as a tax collection fee, because the customer is paying to the hotel through us. We're the merchant of record. And then later, the hotels sort of invoice us, and then we pay, and then the hotels bill taxes. Oftentimes, as a practical matter, Your Honor, the hotels actually remit taxes on the rooms before they even invoice us. And there's no allegation in this case that the hotels have not paid the amount of tax that is due for the room rental rate, which our position is that is the only tax that is owed. So which at issue here is the amount that we as the online travel companies charge customers for our fees, if that answers your question, Your Honor.
But your tax collection fee is based on what you charge the customer, correct?
It is based on the hotel's room rental rate. Again, that portion that we charge the customer for our own services, what's disputed here is whether that is also gross income from owning or operating a hotel, such that the business privilege taxes apply. And our position is that it isn't, because it doesn't derive from the exercise of those privileges.
Well, the argument, as I understand it, is that to take a hypothetical, if you've negotiated a rate of $80 a night for a room, the hotel pays the tax on that room rate.
That's absolutely correct, Your Honor. Yes.
You're basing your tax collection fee off of the amount that you're charging the customer, so there is additional tax that you're collecting as part of your fee and not remitting to the cities, as I understand the argument.
And that is certainly the city's argument. Obviously, we disagree with that characterization. It's clear, certainly from the customer's standpoint, that when we collect funds for the room rental rate, a tax collection fee based on the tax on that, as you say, take the $80, right? Mm-hmm. And an additional amount that's designated for our services, our own fees in the service that we provide to the traveler. That amount is not a tax. That is how the cities have presented it, but that itself is not a tax. Their argument is that we should pay taxes on it. But that amount is not a tax, and it's clearly designated as such in the transactions.
So let's go to what taxes they argue you should pay.
Yes, Your Honor.
And to do that, let's focus on the definitions. I'll be candid with you and tell you that I think your colleagues on the other side are going to have a difficult time persuading me that 447 applies here. Mm-hmm. But 444 refers to persons. Persons include brokers, and as I'm looking right now at the definition of brokers, they sure sound a lot like you. So where in the text of the definition of broker should am I going astray?
Well, I wouldn't want to say that you're going astray, Your Honor, but in terms of, I think, where the trial court went astray, I think there are basically we have essentially four arguments why we are not captured in this definition. And I think first and most important, and we've already talked about this a little bit, so I won't dwell on it, is the fact that both 444 and the definition of broker makes it clear that you have to engage in the taxable business activity, which in this case is either operating a hotel or being a hotel or owning one. And as the
But
trial court agreed, we
isn't
do neither.
advertising for rooms, soliciting customers, collecting customer information, isn't that operating in a hotel?
No, Your Honor. I think we're the
Wouldn't
trial
hotels
court.
be doing that if the OTC didn't do it?
The way I think about it, Your Honor, it's like we would talk to someone who's operating a car. And if I'm driving the car, I'm the operator of the car. If my passenger reaches over and is changing the radio or controlling the radio, we might say, well, that's controlling the radio, but we certainly wouldn't say that my passenger is operating the car. And I think in terms of operating a hotel, and you key in on what the trial court did here. I think the trial court wanted to say, well, if you assist or facilitate a hotel with any of its tasks, then that makes you a broker. Setting aside, that's really not the statutory language, what I was talking with Judge Swan about. I think it's operating a hotel and breaking it into those component parts. And under that conception, Your Honor, even the credit card companies that charge a fee for the fee would fit within the language and would be brokers. And I think everyone agrees that can't be right.
Well, but let's look at the language. The language uses the word business twice.
Yes.
And I believe it uses the word business to refer to two different businesses. Any person engaged in or continuing in business, that's you so far. You're in business, right?
Yes, no dispute about that, Your
Okay.
Honor.
Who acts for another for a consideration. We've got that, right? There's consideration.
Well, let me push back on that, Your Honor. I think the cities, we argue that the for consideration requirement is not met. The cities have conceded that we do not, and I'll quote them, they don't dispute that the OTCs don't receive consideration from hotels. They've conceded that.
That's kind of a form over substance argument, because you're obviously in business to make money. You're receiving the money. It's just that the payments don't come through the hotel. They come directly to you, and then you remit. That is, to say that you're not receiving consideration because you're not receiving it from the hotel strikes me as more of an accounting than a legal or economic concept.
Well, that's certainly not our only argument, and I take Your Honor's point. I will push back a little bit and say that I think, given the principle of statutory construction that applies here, that our reading, we have to offer a reasonable reading. I think it's a reasonable reading of the regulation that the consideration, that a for consideration refers to the person, here the principal hotel, on behalf of whom you're acting. But even setting that aside, I mean, I think another reason that the definition doesn't apply on its face is that the definition's limitation on the amount of taxes to those owed on behalf of the principal, which is here the hotels, isn't satisfied here, as there's no disagreement that the hotel would never owe taxes or amounts paid by travelers. Yes, Your Honor.
That's where I was going next. Who receives for his principal all or part of the gross income from the taxable activity. So here, if the taxable activity is operating a hotel, and you receive for, not from, but for your principal, all of the gross income from that activity, doesn't that make you a broker?
No, Your Honor, and this sort of takes us full circle to my initial argument about the business, just kind of stepping back and looking at the big picture and seeing this as a whole.
Well, let's
it's
look
a
at the
business.
little
It's
picture.
a tax on engaging in the business privilege tax. So it's the gross income from operating a hotel.
Right,
Gross
but I
income
want to
from
focus
that
on the
aspect.
text of the law.
Yes, Your Honor.
Not so much the big picture, because that invites policy choice. I'm really looking at this definition, and I'm trying to see how it is that you don't meet it. So if we could stay in the trees for a moment.
Certainly, and I wasn't trying to get out of the trees of the regulation, but actually going back to the language of the regulation itself and seeing the regulation itself as a whole, and that it's focused on the gross income, on the income that is received on the principal's behalf that derives from the exercise of the conduct of the business privilege, which in our case is operating a hotel.
Okay, but It seems to me like that answer conflated a little bit the concept of taxation and this definition. This definition is just defining who you are. It's not saying who's subject to tax. We get to that later, which is why, in my mind, candidly, I'm drawing a distinction between 444 and 447. But are you a broker? You are, I think, undisputedly receiving all of the gross income from the taxable activity for your principal.
And again, there's a lot to unpack in that question, and let me focus first on, and I want to say I agree with you in terms of the broker. It's a definition. It is not a tax imposition provision. The only tax imposition provisions at issue here are 444 and 447. So broker comes into play, as Your Honor is articulating, right, because you're plugging broker in for person in 444.
Correct.
Exactly. Our point is, even if we were a broker, inserting broker in for person in 444 doesn't alter the fact that we do not engage in the business privilege, as the trial court correctly found, of operating a hotel, just like the federal government is also listed in the definitions of someone who could be a person.
It's an interesting argument, but then why is this drafted to include broker within the definition of person? And then the drafters of this code clearly understood the difference between imposing a tax on a person or imposing a tax on a hotel. They did so one way in one place, one way in another place. So how are we to lend meaning to the language in 444 if we just say that person doesn't mean what it says it means in the definitional section?
To be clear, our argument is not that person doesn't mean what it means. I mean, I think we accept that broker can certainly be plugged in for person in 444, no differently than the federal government or receivership or any of the other large number of entities that are listed. Our argument is that if 444 or 447 doesn't impose tax liability, as the trial court correctly found, when he found that we don't engage in the business of operating hotels, putting the term broker in does not alter that reality.
That makes broker meaningless, right? Because brokers, by definition, don't operate hotels; they're brokers. Yet the definition sweeps brokers into the concept of those who are subject to tax.
Let me disagree with you slightly. I don't think it makes it meaningless in several different respects. A broker, in our view, and our position is, the way that both 444 is written and the way that the broker regulation is written, a broker in this context, and of course the term broker is used in a variety of other provisions, other taxes that aren't an issue here. So I think part of the surplusage issue here has, and I see my time is running. Go ahead. I think part of the surplusage issue here is broker certainly has meaning in a variety of other provisions other than these, but even with respect to 444. The term broker has meaning because it makes clear that in a situation where you have an owner who is liable for the tax primarily and a broker who is operating the hotel, that entity is liable secondarily for it. So the broker regulation has meaning there. It also makes clear that in a situation where an owner wouldn't be liable, would be considered an operator, but wouldn't be liable because its use is casual, that the broker would still be liable to the extent the issue is the usage is not casual. So I think there's at least three ways in which our interpretation actually harmonizes 444 and the broker regulation and doesn't render any of it surplusage. Thank you.
Thank you.
Thank you.
Thank you, Your Honors. May it please the Court. My name is John Kronger. I'll be arguing on behalf of the cities. There are two principal issues that are in this appeal. One is the broker issue that the court has been discussing. And I would just point out that on that issue, it is their burden to find that the trial court was clearly erroneous. There were a finding of fact about the business model, having reviewed the contracts, the business documents, correspondence, the audit file.
Wasn't this a summary judgment?
Was a summary judgment.
Does a clearly erroneous standard apply to summary judgment?
For issues of law that are set out or decided by the trial court, it would be a de novo standard.
Right.
For findings of fact, those are afforded.
De novo, because if there's a dispute of fact, you don't make findings of fact on summary judgment. If there's a dispute of fact, then the court erred in granting summary judgment.
Sure. I don't mean to dispute a fact. Under the undisputed factual record, the court said, oh, the parties may have different labels, but there's no dispute of fact, and everyone agrees with that. The factual record that the court looked at, which was undisputed, is how these companies do business, what their contracts say, what they do, what the amounts charged are, what the tax rates are based on. And my point is that not only was the underlying agency, the cities, entitled to agency deference, as we've briefed, but then when you get to the trial court described the factual record and had that factual record. So my only point is for any reviewing court to say the court got the undisputed facts wrong, that
it would simply be applying the law to the undisputed facts, and I don't want to detain you on standard of review forever,
okay.
but I think that's a de novo review, not a clearly erroneous.
Okay. Yeah, I think we briefed it. We just saw it more as whatever facts are embedded in that order we thought was clearly erroneous standard, de novo in the law, but I'll move on from that point. Secondly, we have the second issue aside from broker is a retroactivity that everyone agrees is a de novo review, in that the court is really not based on any unique fact of these companies or any companies, but really put forth a new legal standard, which is that the laws being on the books, even when they're clear and unambiguous, as was found in this case, that's not enough to trigger liability. That only when the taxing authority, in this case, comes in and actually formally proceeds with an enforcement action, only then does liability start accruing or running on those companies. And that is, with all the briefing set aside, there's not a single case that has ever found or held that position, certainly not a controlling one. Everything in terms of common sense, we all know that ignorance of the law is no excuse. We also know as a matter of Arizona case law that, sure, there are estoppel line of cases, the Valencia case, but those are very narrowly construed when estoppel. That's affirmative action taken and reliance on it. Nothing applies here. We have the 542 provision dealing with if there's some new or differing, and the language differing is used in that section, and read in context with the broader law and principles about how laws work. Clearly it means it embraces or codifies part of those same estoppel principles that inform the Valencia cases. Absolutely, if the cities had come out in 2002 and sent to these would-be taxpayers or tax collectors comfort letters saying, we've thoroughly reviewed your business model, you don't owe taxes, and these companies relied on it, and sometime later the city said, we were wrong and we want 10 or 15 years, that might be a different case. That's not the case we have. And so that's why we cited the hearing officer decisions, like the fifth wheel decision that we put in the record, which said, unless there's been a change in an expressed or a written position, a formal position, there's no change. This court has said, and we cited the case, and I think the DOR cited the case of Miami Copper Company. This was a case that Court of Appeals case that was cited in their briefing, 121 Arizona 150. We fail to see, however, how inaction of the tax commission constitutes a construction of the statute favorable to the taxpayer or otherwise, as evidence of an administrative interpretation on the one hand is, and that goes through some of the facts, it has been stipulated that for many years it has been the practice of taxpayer to deduct from its basis the costs of in-state smelting. So a taxpayer in that case that wasn't paying taxes for some number of years, the tax authority, tax commission, didn't do anything about it. And it says, this court held, mere failure to collect an excise tax due on a previously unassessed value, however, does not amount to construction of an unambiguous statute forever precluding taxing authority.
Before you get to how far back you can go, though, you might want to establish that you can tax that there is a tax liability here.
Sure. But I guess in terms of the two issues, they've obviously appealed the broker decision, and I'm going to address both, Your Honor, with the time that I have.
Yeah.
But what we're appealing from the lower court is the one issue, which is this: we agree with the court on finding them to be brokers.
But that issue won't matter if you lose.
Absolutely. And no matter which one I start, I want to address both of these.
Okay,
So
no problem.
I'm just closing the loop on that the Court of Appeals case law, binding case law up to the Supreme Court under estoppel principles in the Valencia line of cases, the hearing officer decisions that we've cited, such as the fifth wheels, they all say you don't have a change or a differing interpretation unless you have an affirmative position and you switch, and then you get into reliance and does it fit. We don't have that in this case. What we have, the factual record below and here, is that in 2002, one of the cities, Scottsdale, started auditing a company similar to these companies, an online marketer, treated them as broker, expressed that opinion. They litigated it for years. In 2006, the tax court found them to be a broker, Luxury Suites. That was the litigation position, administrative position. In 2007, related to these specific companies, letters went out from the Unified Audit Committee to these companies saying, you are, let's see if I have that provision, saying, online travel companies receiving all or part of the gross income from a taxable activity for their principal are required to be licensed and pay privilege tax on business activity in each Arizona city where their principals are located. All gross income from their online business should be reported under the appropriate business classifications, detailing all available deductions, such as tax collected, and then it goes on from there. Please see the enclosed information on application. This was in May 2nd, 2007, and it went. Ironically enough, their appellate, their amicus brief was by Travel Tech. Travel Tech is renamed, by a travel organization, a member of which is Travel Tech. The predecessor company is ITSA, another trade organization that these companies are members of. And it went to one of the heads of that group, a gentleman named Art Sackler, who was the executive director of what the predecessor of Travel Tech. And so this went to them, and it wrote at the beginning, it said it is the Unified Audit Committee is the interpretive and rulemaking body for Arizona cities and towns. It goes on, talks about the MCTC and the model code, and then it says, and it explains all that. So it went to them, and then it went on and says, we plan to provide notice of the same information to all known online travel companies. That was 2007.
That means that you haven't changed, the cities haven't changed their position.
It's been consistent. 2002, Scottsdale, the audit. Then the audit itself covered years 2000 to 2008, I believe, that time frame. And then, of course, findings of fact from the audit yet again said they were broker. Litigation was filed saying they were broker, and it's remained through 2018.
Careful. Can you explain how and why they are brokers?
Absolutely. So the law, the way I learned, and I believe under Arizona law and any other state, is the proper way to read a statute is not to do what they're seizing on, really in 444 or 47. In other words, don't just go to each of these two provisions, read two sentences, and think you're done. Because if you do that, you aren't doing what the law requires, which is to read all the sections, harmonize them. And so you have to read this law in whole. So we have a number of articles, starting with Article 1. Article 1 lays out all the definitions that are applicable to the entire chapter, not just one section or the other. Broker, I won't repeat it. Your honors know that provision well. Defines person. Person, by the way, and we counted, is used throughout the model code on 106 pages, almost 400 times, counting the code and the regs. Person. Pervasive use in the record-keeping provisions of 300, in the definitions section, in Article 100, importantly in the gross income sections that are embedded in 444 and 47. Gross income. It talks all about gross income to persons or taxpayers.
It actually doesn't talk about that in 447.
No, but what I'm saying, Your Honor, is gross income is in 447.
gross income is in 447.
Right.
But person is not. Hotel
But then we have to go to get gross income and to go get the definition of business. We have to go out of 447, and we have to go look at the definitions for those things.
Well, why would the drafters use person in 444 and not 447?
I don't know why they would change the language, but I can tell you, Your Honor, has worked on these cases, that there, in most states, almost every state, there's a different way they come at their local taxes, but sometimes they arrive at the same point. And so I'm not going to, I cannot.
But to follow your principles about reading statutes, that difference, in the use of the term in one place and not another, has to be given some significance, right?
Well, I think they both have to be read on their own, on their plain language and their own terms. So, what I'm saying is that if one taxing authority, or in this case, one provision is worded one way and another one's worded another, it doesn't always change where they come out. And I've seen this in.
No, but it may here.
It could, and I recognize the distinction, Your Honor. So I don't want to run from that. What I'm saying is, 447 as the court, 444. As the court has already addressed, is very clear about the business activities, including persons of broker. Okay? That law has to be applied on its face, clear, unambiguously, as the trial court correctly did. On the question of 447, where it uses hotel, I certainly grant that it would be an easier interpretive exercise if it had said person yet again there directly. But we have all the other words in the statute in that provision that we have to look at, and one of which is the definition of business. So we got to go out of that section. Business says all activities or acts, personal or corporate, engaged in or caused to be engaged in with the object of gain, benefit, or advantage, either directly or indirectly, and then it says doesn't include casual activities. So we start to get into some very broad language, indirect and direct. What are they talking about?
Well, let me ask you this. If a hotel engages a cleaning contractor to come and clean the hotel every day, I don't doubt that contractor's work might be taxable, but I would doubt seriously that it would be taxable under 447.
Right, and I think it goes back to the question one of your honors asked about the business activities, advertising, marketing, credit card processing, customer service. Let's stay with those core activities.
Let's go to my question. If we have a cleaning company that's clearly an integral part of the hotel business,
sure,
is it your position that contractor is taxable under 447?
No, and for this reason. They aren't touching all the gross income. Let's just say a direct booking. You go to the Hilton. $100 is paid for the room plus taxes on $100, okay, Your Honor? And full taxes are paid by the hotel, even though the hotel is going to have to pay that laundry service, going to have to pay for the valet guy out front, going to have to pay for all those things. In other words, the hotel doesn't get to deduct from the gross income of the whole business activity, the whole pie of services, the bundle of the room and the services. They don't get to deduct it. So, now, this doesn't exist, but let's go with Your Honor's example. Let's imagine the laundry person I'm the laundry guy, but I take in $110 for the hotel. I'm going to take $10 off the top and give $90 to the hotel. We might have a different scenario where all of a sudden they're not just a launderer, but they're somebody taking some of the gross income. They're a person collecting taxes, and they're a broker.
Under 444, I have an easier time with that argument. Under 447, I'm having a difficult time because it sounds like your reading of 447 doesn't even require them to accept the money. This cleaning contractor is certainly engaged in business, and it's doing its business at a hotel. It's necessary to the hotel business. So under your reading, it sounds like that's taxable.
Well, Your Honor, what I'm reading for there's a part of 447 that's as strong or stronger because it directly says within the city in the business of charging for lodging and or lodging space. And we have to wrestle with that phrase, in the business of charging or charging lodging space. So But
we also have to deal with the earlier part of that sentence. It says the business activity of any hotel. It could easily have said the business activity of any person charging for lodging, in which case you'd have a slam dunk. But it doesn't say that.
Well, first off, I just defined business. We've got all these words that would be rendered surplusage because the indirect part. Basically, their argument is if the money flows first to the hotel, it's all taxable. But if somebody else collects the money and skims some off the top, activities that would have been taxable become untaxable. The order of the money matters, and we reject that. If you read this code holistically, it is very clear. The whole point of having broker in there is to prevent problems. The definition I just read for Your Honor about indirect or direct under business covers that. But we go further. The imposition language, you can't get to 447 or 444 without reading 400. 400 is the imposition. 400 says, there are herein levied and imposed, subject to all other provisions of this chapter, and that includes broker provision and the regulation about broker, 100.1. Hereby levied and imposed, subject to all other provisions, the following taxes for the purpose of raising revenue. Everything we ought to be doing in interpreting this code ought to be focused on that purpose for necessary expenses. And then it goes on and it says, under Section C under 400, for the purpose of proper administration of this chapter and to prevent evasion imposed, it shall be presumed that all gross income is subject to the tax until the contrary is established by the taxpayer.
And when it says the tax, what tax does it mean?
Well,
because there are a number of taxes, and we're talking about two today.
correct. And this 400, this section I'm reading applies to all the things found in 400. This is Section 400 that precedes 444 and 447.
Well, but
And notice
But
it says
if I'm selling nuts and bolts at a hardware store, surely I'm not subject to tax under 447, even though 400 would cover me. So we have to look at the individual taxing provisions.
No, I think there's two different things. Everyone's agreeing that the business activity surrounding hotels and charging for hotels, which I just read from 447, that subject matter is relevant. We're not talking about hardware and so on. But what I'm also saying, Your Honor, is now that we're in this space of hotels and charging and collecting for hotel-type charges and activities, that whether they do it directly, charge for it, or whether they do it indirectly, the definition of business covers that indirect model. The presumption, notice it says the gross income right there. It didn't say of hotel. It just said gross income subject to tax established by the taxpayer, and taxpayer again is defined as a person. So you cannot look at 400. You can't look at 447 without 400 in the tax presumption. They don't address that. They also don't address if we think more holistically about this, the Supreme Court of Georgia skinned it a different way and said, forget whether the law in and of itself makes these companies tax collectors with obligations. They've inserted themselves into the taxing scheme by their contracts, which were before the trial court.
Well, so are you saying that the OTCs are hotels?
No, what I'm saying is that if a company who is liable under Arizona law to do something hires by contract another company to do it for them, that doesn't change the law or the tax basis. In other words, private contracts, and they're welcome to have them, that's fine. It's the way the business world works. But a hotel who otherwise has to pay taxes on everything can't write a contract with these companies, and all of a sudden the tax basis goes down.
Well, I'm a simple man, and 447 says the business activity of any hotel engaging, and they're charging for lodging within the city. If the OTCs are hotels, how are they liable under 447?
Well, they could have. I mean, another way to look at it, though, if 447.
Let's look at it the way that I'm looking at it. Tell me why I'm wrong.
Well, because there's a lot of extra words in here. If 447 just said imposes a tax on the gross income or net income of hotels, period, stop. That would mean we wouldn't be here today on that provision, okay? But what it says is it's talking about gross income. That's
Be here because you would agree it's not taxable?
if it was strictly a tax only on brick and mortar hotels, and it had nothing about business activity or gross income, and we didn't have presence and presumption. That's my whole point. Is there's a lot of other words that force you to go beyond 447 and get out of the code.
The problem is, I guess somebody got paid to write this, but it seems like it wasn't written very precisely. I don't know that a hotel is a taxpayer. I don't know that a hotel is a person or an entity. A hotel, in my mind, is a piece of real estate that might be subject to property tax directly. But when they say hotel, the drafters should have specified person, business, some actual entity upon whom the incidence of the tax falls.
Well, I think
it didn't. And by omitting to do that and just leaving us with hotel, the only reasonable interpretation I can come to is the owner of the hotel.
Let me suggest one final point on the gross income point, Your Honor,
Well,
which relates to the.
Let me respond to my concern. Would you?
Well, that would not comport with Section 210. If you construe this to be a net if when these two actors get together, hotel plus the OTC, let's assume they're right, and the tax doesn't cover it. 210 demands that the tax has to be on the fair market value as measured by similar transactions.
I think we're ships passing in the night here. I'm asking, who's the hotel? What does hotel mean in 447?
Just that word with no anything else. The hotel is defined in the code, which says any public or private hotel it's referring to the building, the word hotel.
So when we talk about the business activity of the hotel, that seems to be a restriction on the concept of business activity. We could talk about all sorts of business activity, but here we're just talking about the business activity of a hotel.
Correct. That's true. But then we have to say the gross income business activity of a hotel charging for lodging includes this whole pie or bundle of services. If they outsource part of it, if they do it themselves, it's taxable. But if they outsource part of it, it's not. Respectfully, that's the parts, Your Honor, that is a problem. And if you read the code holistically, and I understand if you seize on one sentence or one section, you could say it's imperfectly drafted and all that. But when you put them all together, and I haven't even quoted 100.1, but I know the Court's familiar, it says wherever necessary in this entire chapter, brokers will be treated as persons to avoid evasion of taxes. They're trying to avoid the escape point I'm making, that you can't get around the gross income of the activity traditionally of hotels. But if they want to get together with others, great, but it doesn't change the tax basis. The order of the money flow doesn't change the tax basis. Itemization, which I didn't get to today, but is throughout this code, Section 250 and 250.1. So if you sit back and you think about it, you go, wait a minute, how do we start off with a tax regime that had gross income of all these business activities? Along come private companies with private contracts. Now part of the tax basis gets reduced. Itemization that was required under 250 and 250.1, which was mandated by the law, you shall separately state deductions, exemptions, exclusions from taxes, even if they wanted to argue that. You shall separately state them or else it's all taxable. That's gone. I mean, in other words, the travelers coming to Arizona aren't getting what Arizona mandates, that you're going to get an itemized bill on your receipt, that you're going to be paying it fairly no matter how you book your room on the full gross income.
I think we're out of time.
Yeah. Thank you. Thank you, Your Honors. Appreciate it.
And we'll add 2 minutes, given that we took you over, if you'd like to add anything by way of rebuttal.
Thank you.
Thank you, Your Honor. I'll just make 2 brief points limited to the retroactivity cross-appeal. First, I won't go through in detail, but virtually all of the evidence that my friend talked about was not in the summary judgment record. It's not record evidence. We go through that in the brief, so I just wanted to highlight that. Second, in terms of Section 542, which governs the retroactivity analysis, another thing, aspect of the statute that's important that my friend didn't touch on, and that is a retroactive application or interpretation is prohibited to a new or additional category or type of business. It's undisputed that the online travel companies didn't even exist when the code provisions at issue were adopted. It wasn't until about a decade later that we came into existence. So I think the trial court's retroactivity holding can be affirmed on that alternative basis as well. if there are no further questions.
Okay, thank you.
Thank you.
Thank you.
All right, thank you very much for your arguments. The matter is now under advisement. We will issue a written decision in due course, and the court stands adjourned.